This decision is lawless, it's destructive, it's dangerous, it's cruel, it's illegal, and it's unconstitutional. Donald Trump has done a lot of bad things in the last week, but nothing's worse than this.
Very responsible measure. Again, the past 4 years, we've seen the Biden administration spend money like drunken sailors. It's a big reason we've had an inflation crisis in this country, and it's incumbent upon this administration to make sure, again, that every penny is being accounted for honestly.
Those affected by President Trump's federal funding freeze have a little longer to clear up confusion over the order. A federal judge has temporarily halted it. Earlier today, top Senate Democrat Chuck Schumer sharply criticized the action.
Okay, so Trump's financial empire is in absolute crisis after a federal judge issued an emergency order freezing virtually all Trump Organization assets following bombshell findings of systematic fraud and Trump's failure to post the required bond to delay a massive civil judgment that could fundamentally destroy his business legacy. We're talking about a New York federal court that has essentially paralyzed Donald Trump's entire business empire, freezing real estate holdings, business accounts, and personal finances, including iconic properties like Trump Tower, Mar-a-Lago, his hotels, and his golf courses. Trump cannot sell, transfer, hide, or leverage any of these assets right now, which leaves him completely unable to pay mounting legal bills, secure new loans to cover his obligations, or shift properties to family members or shell companies to protect them from seizure. This is the kind of financial catastrophe that business moguls have nightmares about. Waking up one day to discover that a court has essentially taken control of your entire empire, and you can't access your own money or properties without permission from judges and court-appointed monitors who are watching every move you make. The court's order was triggered by Trump's failure to post hundreds of millions of dollars in bond that was required to delay enforcement of the landmark fraud judgment, which found that the Trump Organization systematically inflated property values to obtain favorable bank loans and insurance deals over many years in what prosecutors called a pattern of fraudulent conduct that went right to the top of the organization. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video.
Funding for Meals on Wheels or for school lunch programs or things like that, I mean, there's got to be a real scare among some of them. Does that have the potential to force the president, the White House, to pull back and change course?
Well, I think that they just didn't have a ton of answers about all of the programs affected. And we saw that in the first White House briefing today by Press Secretary Caroline Leavitt. You know, she kept emphasizing that benefits that go directly to people like Medicare and Social Security aren't affected. But there's a ton of benefits that do flow through states like Medicaid or through nonprofits that then flow to people like Meals on Wheels. And there's just a real lack of clarity about sort of how the sweep of this federal funding freeze and you know what it actually looks like.
The freeze covers all major Trump Organization assets nationwide. We're not just talking about one or two properties. We're talking about his entire portfolio of real estate holdings, business operations, and financial accounts that represent the foundation of everything Trump has built his identity and political brand around. Trump Tower in Manhattan, Mar-a-Lago in Palm Beach, his hotels in Washington and Chicago, his golf courses scattered across multiple states and countries, all of it is now frozen and potentially subject to seizure if Trump doesn't satisfy the massive judgment against him. If Trump doesn't pay what he owes, authorities have the legal power to seize or liquidate these assets to satisfy the debt, which means Trump could literally watch his properties being sold off piece by piece to cover the penalties from the fraud judgment. This isn't just financially devastating, it's psychologically and politically catastrophic for someone whose entire public persona is built on being a successful businessman and real estate mogul. The image of Trump as the guy who builds towers with his name on them becomes pretty hard to maintain when those towers are being seized by courts and sold off to pay fraud penalties, and Trump's political opponents are absolutely going to hammer him on the narrative that his business success was built on fraud and that he's now losing everything because he couldn't follow the law. Trump's attorneys have been scrambling desperately after the bond deadline expired, trying to find some way to either come up with the massive amount of money needed to satisfy the judgment or to get courts to delay enforcement while appeals play out. Legal experts are calling this the most aggressive financial action ever taken against a former president. And they're noting that the combination of the fraud findings and the asset freeze creates a perfect storm of legal and financial pressure that Trump has never faced before, despite his many other legal challenges over the years. The paralysis of his assets means Trump can't use his properties as collateral to secure loans that might help him pay his legal bills or cover the judgment. And he can't engage in the kind of financial maneuvering that he's used throughout his career to stay solvent despite various business failures and bankruptcies. Financial circles across Wall Street are reportedly in a state of panic as banks that have relationships with Trump or his organization are freezing accounts and reassessing their exposure to what's looking more and more like a collapsing financial empire. The ripple effects of Trump's asset freeze are spreading throughout the business world as people who have deals with Trump companies or who hold Trump debt are trying to figure out what this means for their own financial positions and whether they need to take protective action. The potential for court-appointed receivers to take control of Trump assets and manage or sell them off if payment isn't made adds another layer of humiliation and loss of control that has to be eating at Trump psychologically. Receivers would essentially step in as managers of Trump's properties, making decisions about operations, potentially selling off assets to satisfy the judgment, and generally treating the Trump organization like a distressed company that needs professional management to protect creditors and satisfy legal obligations. For someone like Trump, who has always insisted on total control over his business empire and who has built his brand on being the boss who makes all the decisions, having court-appointed managers running his properties and potentially deciding to liquidate them would be an absolutely crushing blow to his ego and his public image. The business empire that Trump has spent decades building and that he used as his launching pad into politics could be dismantled by court officers acting under judicial authority, and there's nothing Trump could do to stop it unless he comes up with the money to satisfy the judgment. The implications for Trump's political campaign and his ability to fund his various legal defenses are enormous because his entire strategy has been built on being able to tap his business assets for cash when needed and to use his wealth as both a political selling point and as a practical resource for campaign operations. If Trump's assets are frozen and potentially being sold off to satisfy court judgments, he can't use them to finance his campaign or to pay the armies of lawyers he needs for his multiple legal battles. Donor confidence could crater as supporters who were giving money thinking they were backing a successful businessman start to wonder whether they're actually propping up someone whose financial empire is collapsing under the weight of fraud penalties and legal judgments. The campaign funding implications are particularly serious as the 2025 election season approaches, and Trump needs massive amounts of money for advertising, ground operations, legal fees, and all the other expenses that modern presidential campaigns require. If he can't tap his own assets, and if donors start getting nervous about his financial viability, Trump could find himself in the unprecedented position of being a major party presidential candidate who's effectively broke and unable to compete financially with his opponents. The fraud findings that led to this asset freeze are themselves damaging beyond just the financial penalties because they validate what Trump's critics have been saying for years about his business practices being built on deception and manipulation rather than genuine success. The court found that the Trump organization systematically inflated property values, telling banks and insurance companies that properties were worth far more than they actually were in order to get better loan terms and lower insurance premiums. That's textbook fraud that any business student would recognize as illegal and unethical, and the fact that it was systematic rather than isolated incidents means the court concluded this was how Trump's organization routinely operated rather than being occasional mistakes or judgment calls. For Trump supporters who have defended him as a brilliant businessman who just plays hard and uses the system to his advantage, these findings make it much harder to maintain that narrative. This isn't aggressive, but legal business tactics. This is fraud that courts have now conclusively found and are imposing massive penalties for. The political impact of having fraud findings attached to Trump's business record could be significant with independent voters who might have been willing to overlook other Trump controversies, but who draw the line at systematic financial fraud. Let's examine the legal mechanics of how we got to this point of asset freezes and potential seizures, because understanding the timeline and the court proceedings helps explain why Trump is now in such dire financial straits. The fraud case that led to this judgment was brought by New York Attorney General Letitia James, who conducted a lengthy investigation into Trump Organization business practices and concluded that there was a pattern of fraudulent valuations being used to deceive banks and insurance companies. The investigation uncovered documents showing that Trump properties would be valued at wildly different amounts, depending on whether Trump was trying to get loans, where he wanted valuations as high as possible, or trying to minimize tax obligations, where he wanted valuations as low as possible. The same property would be listed as worth hundreds of millions in loan applications, but far less in tax filings, and the discrepancies were so large and so systematic that they couldn't be explained as good faith differences of opinion about valuation methodologies. The court found that this wasn't just aggressive accounting or creative interpretation of property values. It was deliberate fraud designed to deceive financial institutions and gain advantages that Trump wouldn't have gotten if he'd been honest about what his properties were actually worth. The judgment against Trump was massive, running into hundreds of millions of dollars when you add up the penalties and the requirement to disgorge profits that were obtained through fraud. Trump was ordered to post a bond for the full amount if he wanted to delay enforcement while pursuing appeals, which is standard procedure in civil cases where defendants want to avoid having to pay immediately while they challenge the verdict. But Trump has apparently been unable to secure a bond for the amount required, which tells you something significant about his actual financial position and his ability to get financial institutions to back him. Bond companies assess risk before they'll issue bonds. They want to be confident they'll get their money back if they have to pay the judgment on behalf of the defendant. The fact that Trump can't find a bond company willing to back him for this amount suggests that financial professionals who've looked at his situation don't believe he has the assets or liquidity to ultimately satisfy this judgment, or at least they're not confident enough to put their own money at risk by issuing the bond. That's a devastating assessment of Trump's financial position from people whose business is evaluating financial risk, and it contradicts Trump's longtime claims about being worth billions and having tremendous wealth. The emergency nature of the asset freeze reflects the court's concern that Trump might try to move, hide, or dissipate assets to avoid having them available to satisfy the judgment if he ultimately loses on appeal. Courts have broad authority to freeze assets when there's concern that a defendant might try to become judgment-proof by transferring property to family members, shell companies, or offshore entities that would be hard for plaintiffs to reach. In Trump's case, the court apparently concluded there was sufficient risk of asset dissipation that an immediate freeze was necessary to protect the ability to collect on the judgment. That conclusion is based on Trump's history and pattern of using complicated corporate structures, his tendency to move assets between entities, and perhaps evidence that emerged during the case about plans or discussions regarding protecting assets from enforcement. The fact that the freeze is so comprehensive, covering virtually all Trump Organization assets rather than just specific properties, shows how concerned the court is about Trump's ability and willingness to manipulate his business empire to avoid paying what he owes. The practical implications of having all these assets frozen are difficult to overstate because it essentially prevents Trump from operating his businesses normally or accessing the value that his properties theoretically represent. Real estate empires like Trump's typically operate with significant leverage, using properties as collateral for loans, refinancing properties to access equity, and constantly moving money between different entities to manage cash flow and take advantage of opportunities. With everything frozen, Trump can't do any of that financial maneuvering that real estate developers rely on to keep their operations going. He can't take out a loan against Mar-a-Lago to cover legal bills or campaign expenses. He can't sell a golf course to raise cash even if he wanted to. And he can't transfer properties to family members or trusts that might offer some protection. The freeze essentially turns what might be billions of dollars in property value on paper into assets that Trump can't actually use or benefit from, which makes him cash poor even if he's technically asset rich. That's a nightmare scenario for someone facing massive legal bills and political campaign costs that require actual liquid funds rather than just property that's valuable in theory. The ripple effects through financial markets and business relationships are also significant because Trump's businesses don't operate in isolation. They have relationships with banks, insurance companies, vendors, employees, customers, and partners who all need to reassess what Trump's financial crisis means for them. Banks that have outstanding loans to Trump entities are probably trying to figure out whether those loans are at risk and whether they need to take protective actions like demanding early repayment or seizing collateral while they still can. Insurance companies that provide coverage for Trump properties are reassessing their exposure and potentially adjusting coverage or premiums based on the increased risk profile. Vendors who do business with Trump properties, providing services, supplies, or products, are wondering whether they'll get paid and whether they should continue providing services on credit. Employees at Trump properties are worried about whether their jobs are secure if properties start getting sold off or if the organization enters some kind of financial restructuring. And business partners or licensees who have deals involving the Trump name are reconsidering whether that association is now a liability rather than an asset given the fraud findings and the financial crisis. The potential for asset liquidation to satisfy the judgment raises fascinating questions about what Trump properties would actually fetch in forced sales and whether the Trump brand adds value or subtracts value in the current environment. Trump has always claimed his properties are worth far more than objective valuations suggest, arguing that the Trump brand itself has enormous value that should be factored into property values. But the fraud case essentially concluded that Trump was grossly overstating property values, which suggests that if properties actually go to sale, they might fetch far less than Trump has claimed they're worth. And in forced liquidation scenarios where assets are being sold quickly to satisfy judgments rather than being marketed properly over time, properties typically sell for significant discounts compared to what they might get under normal market conditions. The Trump brand itself has become increasingly polarizing. There are consumers who specifically seek out Trump properties because they support him politically, but there are also consumers who actively avoid anything with the Trump name because they oppose him. A buyer acquiring Trump Tower or Mar-a-Lago would have to evaluate whether keeping the Trump name helps or hurts the property's value, and that calculation might lead to significant rebranding, which would be its own kind of humiliation for Trump, watching his name literally being stripped off buildings. The political exploitation of Trump's financial crisis by his opponents is already beginning, and will only intensify as this situation develops. Democrats and anti-Trump Republicans are going to hammer the narrative that Trump's business success was built on fraud, that he's now losing everything because he couldn't follow the law, and that someone who couldn't manage his own finances honestly certainly can't be trusted to manage the country's finances. The image of Trump as the successful businessman who knows how to make deals and create wealth has always been central to his political appeal, and having that image shattered by fraud findings and asset seizures could be politically devastating with voters who supported Trump specifically because they admired his business success. The practical constraints on Trump's campaign operations created by his financial crisis will also become fodder for political attacks. If Trump can't afford the advertising and ground game that modern campaigns require, opponents will point to that as evidence he's weak and failing, and the spectacle of Trump's properties potentially being sold off to satisfy court judgments will provide endless opportunities for visual storytelling about a business empire in collapse that undermines everything Trump has claimed about his success and competence. So, what are Trump's options at this point for dealing with this financial catastrophe, and what are the likely scenarios for how this plays out over the coming months? Trump's most obvious option is to try to come up with the money to satisfy the judgment, either by liquidating some assets voluntarily on better terms than he'd get in a forced sale, or by finding lenders willing to provide financing despite his current legal and financial problems. But both of those options face significant practical obstacles. Voluntarily liquidating assets requires being able to sell them, which the asset freeze may prevent, and finding lenders willing to provide massive amounts of financing to someone facing fraud judgments and asset freezes is extraordinarily difficult. Traditional banks are unlikely to touch Trump at this point, given the reputational and regulatory risks, and alternative lenders who might consider risky deals would demand such punitive interest rates and terms that Trump might decide he's better off taking his chances with the courts. There's also the question of whether Trump even wants to liquidate assets voluntarily, because doing so would mean admitting defeat and accepting the legitimacy of the fraud judgment, which goes against everything in Trump's nature about never admitting wrongdoing or backing down from fights. Trump's legal strategy will likely focus on trying to get the asset freeze lifted or limited while he pursues appeals of the underlying fraud judgment, arguing that the freeze is overly broad and causes unnecessary harm to his businesses and his ability to mount a legal defense. He'll argue that he should be allowed to operate his businesses normally and access reasonable amounts of funds for legal fees and campaign operations while the appeals process plays out, and that freezing everything is excessive given that he's not actually at risk of fleeing the jurisdiction or completely dissipating all his assets. Courts sometimes grant limited relief in these situations by allowing certain business operations to continue while maintaining the freeze on major asset transfers or sales, and Trump's attorneys will push hard for that kind of middle ground that lets him function while still protecting the state's ability to collect on the judgment. But courts are typically skeptical of these arguments when there's evidence that defendants have previously engaged in asset manipulation or when the underlying conduct involved systematic fraud. And the judge who issued this freeze apparently concluded that comprehensive asset protection was necessary based on Trump's specific circumstances and history. The appeals process for the underlying fraud judgment will take months, if not years, to fully resolve, which means Trump could be living under this asset freeze for an extended period while legal arguments play out through various levels of courts. Trump's appellate attorneys will argue that the fraud findings were legally incorrect, that the penalties were excessive and not justified by the actual harm to banks or insurance companies, and that various procedural errors occurred during the trial that warrant reversal or at least reduction of the judgment. New York appellate courts will review those arguments. And if Trump loses at the state appellate level, he could potentially try to take the case to federal courts or even the U.S. Supreme Court on constitutional grounds. But appeals that succeed in completely overturning fraud judgments are relatively rare, especially when trial courts made detailed findings of fact about systematic fraudulent conduct over many years. Trump's more realistic hope on appeal is probably getting the penalties reduced rather than having the fraud findings completely thrown out. But even reduced penalties could still be in the hundreds of millions of dollars that he'd struggle to pay given his apparent cash flow problems. The political impact of this financial crisis on Trump's campaign is difficult to fully predict because Trump has shown remarkable ability to turn apparent weaknesses into strengths by claiming he's being persecuted and rallying his base around narratives of victimization. Trump will certainly argue that the asset freeze and fraud judgment are politically motivated attacks designed to destroy him because the establishment fears his return to power. And many of his supporters will believe that narrative regardless of the actual legal merits of the case. The fact that the Attorney General who brought the case is a Democrat who campaigned partly on investigating Trump will feed into claims about political prosecution, even though the case was heard by an independent judge who made findings based on evidence rather than political considerations. Trump's fundraising appeals will emphasize that he's under attack and needs financial support from ordinary Americans to fight back against corrupt elites trying to destroy him, and that message has historically been very effective at generating donations from his base. The question is whether this financial crisis reaches a level of severity that even some of Trump's supporters start to question his competence and viability, or whether the persecution narrative remains powerful enough to maintain his political coalition, regardless of his financial problems. The long-term implications for Trump's business legacy are profound because even if he somehow manages to satisfy the judgment and get the asset freeze lifted, the fraud findings will permanently taint his business reputation and make it much harder to operate in legitimate financial markets. Banks, insurance companies, and business partners will be extremely reluctant to work with someone who courts have found engaged in systematic fraud, regardless of whether Trump personally admits wrongdoing or blames it on subordinates. The Trump brand itself, which Trump has always claimed is worth billions, has been severely damaged by the combination of polarizing political positions and now conclusive fraud findings, making it much less valuable as a licensing or marketing tool. Properties that bear the Trump name may need to be rebranded to maximize value, and new development projects using the Trump brand will face resistance from lenders, partners, and customers who don't want to be associated with fraud findings. Trump is 78 years old, and the realistic possibility is that his business empire won't recover from this crisis during his remaining years, meaning his ultimate business legacy will be as someone who built a large real estate portfolio through fraudulent practices and then lost it all to court judgments and asset seizures. The potential for this financial crisis to affect Trump's legal strategy in his various criminal cases is also worth considering because defendants need resources to mount effective defenses, and Trump's frozen assets limit his ability to pay for the high-priced legal talent he needs. Trump is facing multiple criminal prosecutions in different jurisdictions, and each of those cases requires teams of experienced attorneys who don't come cheap. If Trump can't access his assets to pay legal bills, and if he's having trouble raising enough money through political fundraising to cover both campaign operations and legal defense costs, he may have to make difficult choices about which cases get priority and which get less resources. That could lead to less effective legal defenses than Trump would otherwise mount, potentially increasing his legal vulnerabilities in cases where outcomes might depend on having the best possible legal representation. The irony of Trump's financial crisis potentially compromising his ability to defend against criminal charges because of a civil fraud judgment would not be lost on his critics, though Trump's supporters would frame it as yet more evidence of a coordinated campaign to destroy him. The spectacle of a potential president's financial empire collapsing while he's running for office is unprecedented in modern American politics and raises questions about what voters make of someone who's simultaneously seeking the most powerful office in the world while losing control of his business empire. Presidential candidates are typically expected to demonstrate competence, success, and the ability to manage complex organizations. And while voters might be willing to overlook various personal failings, having courts conclude that your business success was built on fraud and watching your assets be seized to satisfy penalties seems like it would undermine claims to competence and trustworthiness. Trump has always argued that his business success qualifies him to run the country and that he can apply business principles to government. But that argument becomes much harder to make convincingly when his business empire is in court-ordered receivership and his properties are being sold off to pay fraud penalties. The counter-argument that this is all politically motivated persecution might work with Trump's committed supporters, but independent voters who might have been attracted to Trump's business credentials could reasonably conclude that someone who can't manage his own finances honestly shouldn't be managing the federal government. Looking at this situation from a historical perspective, the aggressive legal and financial pressure being brought to bear on Trump through various civil and criminal cases represents an unprecedented attempt to hold a former president and current political candidate accountable through legal mechanisms that would apply to any other citizen. The constitutional questions about whether someone facing this level of legal and financial jeopardy can effectively serve as president are serious and will likely become more prominent as this situation develops. Can Trump effectively govern if he's dealing with asset seizures, potential criminal trials, and constant legal battles that would consume enormous amounts of time and attention? Would having a president whose finances are in court-ordered receivership create national security vulnerabilities or compromise his ability to make decisions in the national interest rather than his personal financial interest? These aren't just theoretical questions, they're practical concerns about governance and presidential capacity that voters will have to grapple with if Trump remains a viable candidate despite his financial and legal crises. The Founding Fathers never anticipated a scenario where someone facing multiple criminal prosecutions and civil asset seizures would be running for and potentially winning the presidency. So there's no clear constitutional framework for how to handle this situation, which leaves courts, political institutions, and ultimately voters to figure out how to navigate unprecedented territory without clear guideposts or historical precedents to rely on.